All right. Good morning, ladies and gentlemen. Now I'm ready. Now I'm ready. Good morning, ladies and gentlemen. I'm gonna try it again. Good morning, ladies and gentlemen. All right, and thank you for joining us. I'm Henry Floyd Jr., the president of the Washington Council of Lawyers, and it's my esteemed privilege to welcome you to our 2025 Summer Forum. Now, you'll see I am biased, but the WCO Summer Forum is the best program in all of DC. Okay, let me get a little bit of claps or something. Okay. All right. And so you all are in for a treat today. Before I introduce the superstar in our presence today, I would like to take a moment of personal and presidential privilege and recognize two people who are responsible for making today and every day happen at the Washington Council of Lawyers. Our incredible executive director, Christina Jackson. She is in the back of the room. And our amazing program director, Chris Marin, who is taking photos in the back of the room. And I would also like to recognize members of our board of directors. Please raise your hands or stand. I got a couple of them in the room. All right, round of applause for them as well. All right, now there are very few people who pique your interest and admiration when you hear their names because they genuinely love to help people and do the actual work. Representative Jamie Raskin is one of those names because he cares about people and his illustrious career proves it. He is a double Harvard grad, Harvard College and Harvard Law School. He is a former editor of the Harvard Law Review. He was a constitutional law professor at American University's Washington College of Law for more than 25 years. He has authored several books and is a Washington Post and New York Times #1 best-selling author. He served 3 terms as a Maryland state senator where he served as majority whip and delivered landmark legislative accomplishments on issues including marriage equality, abolition of the death penalty, and the restoration of voting rights, amongst other important issues. He served on the infamous bipartisan January 6th Select Committee and led its legal and constitutional team. He was appointed by Speaker Emerita Nancy Pelosi as the lead impeachment manager in the second impeachment trial of President Donald Trump, making him only the 4th member of Congress to serve as the lead presidential impeachment manager in American history. He served as the ranking member on the Oversight Committee. He served as the ranking member of the House Judiciary Committee in the 119th Congress. And on January 6, 2025, he was sworn into his 5th term representing Maryland's 8th Congressional District in the United States House of Representatives. He is one of those names that always comes up when we as American citizens think about who actually fights for us and our rights. Ladies and gentlemen, without further ado, I bring you the incomparable United States Representative Jamie Raskin.
Well, hello, everybody. Henry, thank you for that lovely introduction. Thanks to all the summer associates and interns who have come out to have this conversation today. My charge has been to talk about pro bono and the fundamental importance of pro bono in terms of your careers and your work. And I'm psyched to be with you at this moment of obviously high danger for American constitutional democracy and freedom when lawyers have the chance to become great heroes in this fight of our lives or great villains. You know, it's the choice is yours, the choice is ours, what we're going to do at this point. I know a story that my dad told me. My dad worked for President Kennedy, and he told me a story about Robert Kennedy, the real Robert Kennedy, the real Bobby Kennedy, who was a young aide on a young lawyer on the Senate racketeering committee, and they called Jimmy Hoffa to come forward, who was a labor leader. I don't know. I wonder if have you guys heard of Jimmy Hoffa? You know, okay, so, but he was a labor leader, but he was kind of mobbed up, and So in starting his questioning of him, Kennedy leaned forward and said, Mr. Hoffa, as the international president of the International Brotherhood of Teamsters and the Secretary General and Treasurer of the Mid-Atlantic Pension Teamsters Fund, a man of your extraordinary power and position in office is capable of doing both very great good and very great evil. And Hoffa leaned forward into his microphone and he said, I intend to live up to both of my responsibilities. And I was thinking about that this morning because the stakes are high for you as young lawyers, and you really have the opportunity to choose what kind of career you're going to design for yourselves and what you want to do with it. The subject of pro bono could not be more pressing at this moment. We live in a time when the demand for pro bono services is absolutely overwhelming and urgent because the Constitution, the democracy, voting rights, the rule of law, personal freedom, all are under sustained daily attack right now across the country. And yet the supply of qualified pro bono lawyers is scarce. It is dwindling for reasons that are probably apparent to you, but I'm going to discuss just to lay out the supply-demand economics of the situation. The demand is extraordinary because the Constitution is under assault from the preamble to the supremacy clause in Article 6. From the beginning of the Constitution to the end of the Constitution, everything's under attack, right? We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and preserve to ourselves and our posterity the blessings of liberty, do hereby ordain and establish the Constitution of these United States of America. There's our preamble, our mission statement, and it's been completely turned upside down. We the people have suddenly been subordinated from the sovereign authors of the democratic experiment to the subjects of a president behaving like a king. But the very next sentence of the Constitution kicks off Article 1. All legislative power is vested in a Congress of the United States, all lawmaking power. And then you get page after page after page of all of the lawmaking powers that Congress has: the power to pass budgets, the power to approve taxes, the power to declare war. If anybody's going to declare war on Venezuela, it's Congress who's going to do it, not the president, not Tulsi Gabbard, not anybody in the executive branch. Only the Congress can do that. Congress has the power to set up the federal agencies and departments. Congress has the power to appropriate money, not the president. And a legislative appropriation, an Appropriations Act is a federal law, like the law saying you cannot assault a federal officer. So it's not a budgetary recommendation. If it's gone through the House, it's gone through the Senate, it's passed out, it's gone to the president, then the president signs it, it's law. If the president vetoes it, Congress can vote by 2/3 to override the veto. If the Congress does, then it's law. If it fails to override the veto, it's not law. But either it's law or it's not law. If it's law, the job of the president is what? Well, under Article 2 of the Constitution, it's very clear what the president's job is. There's not much else in there. The most important paragraph actually says that a president shall be removed from office upon impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors, right? Sometimes my colleagues will get up and say, beseechingly, we're three co-equal branches treat us like a co-equal branch. And I'm like, get up off your knees. We are not a co-equal branch. For one thing, the word co-equal is not even a word, okay? That's not a word. That's like extremely unique or something like that. Are we three equal branches? I don't think so. The Congress is in Article 1 for a reason. We had a revolution against a king, against a monarch, against formal establishment of church and state, state-run religion. We had a revolution against the lords, against feudalism. In the Articles of Confederation, we didn't even have a president. The president was added in the Constitution, not exactly as an afterthought, but certainly as a secondary thought to governance by the people, the representatives of the people. If we're co-equal branches, why does Congress have the power to impeach, try, convict, remove, and disqualify a president for engaging in treason, bribery, and other high crimes and misdemeanors? And the president doesn't have the power to impeach and try and convict and remove and disqualify us. The framers had a lot more fear of a president who tried to usurp the powers of Congress and arrogate to himself the powers of a king than they had of the powers of Congress. And they didn't think, the people were infallible or anything, but they reposed a lot more faith in the wisdom of crowds and in the many than in the ambitions of the one. Why does Congress have the power to declare war and not the president? Well, because the kings were constantly plunging their nations into wars of whim and vanity and greed and avarice and imperial intrigue. And the framers thought that the representatives of the people would be doing a lot better job than the president in terms of thinking through all of the implications of foreign entanglements and military adventure abroad. So what is the core job of the president? Well, there's commander-in-chief, not of the nation, not of the government, commander-in-chief of the Army and the Navy and the militias in times of actual service, right? What is the job of the president? To take care that the laws are faithfully executed, to implement and execute the laws that have gone through bicameral passage and presentment to the president. They've been signed into law. Now, your job is to, I like to say, go and pick up the pizza, because I've seen my kids and all their cousins, and they spend hours talking about what kind of pizza to get. And, one time they decided we're going to get pepperoni and pineapple, and then the cousin who went to pick it up decided to change the whole thing around and get sausage and hamburger. He was acting as the executive at that point. You just go and you pick up the pizza. The lawmaking process has already taken place. And so Donald Trump does not have the power to impound funds that have been appropriated by Congress. He doesn't have the power to redirect and divert funds that we've appropriated for particular purposes. I don't care how much he hates it. He doesn't have the power to defund the Department of Education or the Agency for International Development or the NIH. That's a matter of law. And that's why we're winning in all of these cases, at least until we get to the Supreme Court, where we've been winning all of these cases all over the land. More than 95% of the cases we're winning in the district courts and in the appeals courts. But that basic structure of our Constitution is under attack. That's why we've got Article 3, right? Chief Justice John Marshall says in Marbury versus Madison, 1803, it is emphatically the province and the duty of the judicial department to say what the law is. That's the job of the court. No, J.D. Vance, I don't know what they're teaching you at Yale Law School these days. It's not the job of the president to get to declare what the limits are on the power of the president. And of course, he doesn't think that there are any. And as Donald Trump repeatedly says, oh, and of course, I've got my Article 2, which means I can do whatever I want. No, that's what Marbury versus Madison is about, right? Madison wasn't president at that time. He was Secretary of State. And the Supreme Court said it's perfectly fine for the court to send an injunction, a decision to an executive branch officer to tell them they've got to comply with the law. Now, it turned out the court also determined that they didn't actually have jurisdiction over this particular case because the Judiciary Act had unconstitutionally enlarged the powers of the Supreme Court and didn't have jurisdiction over that particular case. But the court was emphatically clear that when there's jurisdiction, of course, the court can order an executive branch official to do something or strike down a law of Congress or an action of the state, because it's emphatically the province and the duty of the court to say what the law is. That is the role of the court to do it. So we also need to reestablish the supremacy of the court. Unfortunately, what we've got is justices on the court who are either in direct collaboration with Trump and his power grabs, or are afraid and are nervous to do it and are looking for ways, however they can, to appease him and flatter him and soothe his constantly wounded ego by pulling a rabbit out of the hat, as with the birthright citizenship executive order case. I mean, this is blatantly unconstitutional. It's been struck down by 4 federal district courts, 2 judges appointed by Republicans, Reagan and Bush, 2 appointed by Democrats, Obama and Biden. The Reagan judge said this was the most unconstitutional thing he had seen in his 4 decades on the bench. The easiest case to decide. You don't have to be a lawyer to figure this out. You just have to know how to read, he said. You just have to know how to read. The very first sentence of the 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. 4 district courts, 3 appellate courts all decided it. It goes up to the Supreme Court. And what do you know? They're not going to address the substance of the case. Instead, they're going to find for the first time since the Judiciary Act of 1789 that federal district courts do not have the power to impose universal injunctions, nationwide injunctions. Something, of course, the Republicans had no problems with when Biden was president, and they were lined up around the block for the judge in Amarillo, Texas, Judge Kaczmarek, I think is his name, who was imposing nationwide injunctions on mifepristone and whatever culture war item was up for grabs at that point. But they used this as an opportunity suddenly to say that the Judiciary Act of 1789, which created courts of equity, couldn't do this. It wasn't sufficiently analogous to anything they were doing at the time, which mixed up their originalist constitutional jurisprudence with the statutory interpretation question of the Judiciary Act of 1789. It was all about allowing for equity. And what is equity? It is allowing for the evolution of remedies of the court in order to meet the problems caused by the actions of the tortfeasor or the government violating people's constitutional rights. It's a ridiculous opinion. But in any event, the structures of government and federalism, the separation of powers are all under attack. But that's not all. The heart of it, of course, is the assault on the Bill of Rights, the rights of the people, which is what the whole thing is about. That's why we have the structural protections in the Constitution, is also to protect the rights of the people and to prevent usurpation of all powers. As Madison put it in Federalist 10, the very definition of tyranny is the collapse of all powers, executive, legislative, and judicial, into one, right? It is the separation of powers that helps to protect our freedom. But now we've got an attack on everything, on the freedom of speech, on the freedom of press, right? People are being rounded up and they are attempting to deport them from the country for having gone to a rally taking a position the president doesn't like. They wrote an op-ed for their college newspaper, and they're trying to deport them from the country. We've got media entities like the Associated Press being kicked out of White House functions because they insist on calling the Gulf of Mexico, which you're not allowed to do anymore, because you can only tell the truth if that truth is approved by the administration. The Federal Communications Commission has been weaponized against the media. And in his inimitable way, the commander-in-chief of the Army and Navy and the militias in times of actual service, has also decided he's going to use the power of the FCC as an opportunity for a shakedown against ABC and CBS and NBC, right? So CBS has 60 Minutes. The president sued them for hundreds of millions of dollars because he didn't like the way they edited an interview with Kamala Harris. And what do you know? They're also coming before the FCC looking for approval for the sale of one of their licenses, one of their broadcast licenses. And so he's got them over a barrel. They settle in his utterly ridiculous, absurd case for $20 million in order to see the sale go through. And it's NPR and it's PBS, the constant attack on the media with personal lawsuits to go along with it. Why not throw in the profit motive as well as the ideological control of the press at the same time? And this is the First Amendment in the United States of America in 2025. The separation of church and state is under constant attack and assault. I had a colleague who got up not long ago on the floor who said that the moral downfall of America was in 1962 in Engel versus Vitale when the Supreme Court banned prayer in the public schools. And I got up to say, no, the Supreme Court never banned prayer in the public schools. As long as there are pop math quizzes, there will always be prayer in the public schools. Anybody can pray whenever he or she wants to pray. All the Supreme Court found under the Establishment Clause is the government cannot compose a religious script and compel your children to participate in it. But it doesn't end. Louisiana and Texas just voted to endorse the Ten Commandments, to post the Ten Commandments in every public school classroom. And I knew it was going to happen. My MAGA colleagues came in. We need to endorse the Ten Commandments. We need to post the Ten Commandments. Really, I said the Ten Commandments have been doing fine for millennia without an endorsement by the U.S. House of Representatives. No, one guy, he convinces me or tries to convince me. He says, no, the Ten Commandments are the basis for the Bill of Rights. I said, well, I know there are 10 in each one. I concede that point. But let's test the proposition. The first commandment is, thou shalt have no other God before me. The First Amendment is, Congress shall make no law respecting an establishment of religion, nor prohibiting the free exercise thereof. How does the First Commandment dictate the First Amendment? But that argument doesn't convince them. We go to the Rules Committee. They want an up or down vote on the Ten Commandments in the year of our Lord, 2025. They want the whole Congress to vote on the Ten Commandments. I said, you know what? If we're going to vote on the Ten Commandments, then we should have to vote on each commandment separately, okay, and not have the omnibus package. And you shouldn't be allowed to vote for any commandment you yourself have ever violated, because then you'll be taking the name of the Lord in vain in violation of the third commandment. But this doesn't end, this push for Christian white nationalism to become the official ideology of the government. Due process, the two most beautiful words in the English language, are under attack constantly. Whether we're talking about the rights of immigrants, we're talking about the rights of federal workers, the rights of anybody being stopped on the street now, due process under attack. It is due process which separates the rights and freedoms of the people from arbitrary state power. And I've got colleagues who say to me, well, you're not for due process for guilty people, are you? I said, that's the whole point. We don't know if they're guilty or not until we've actually had due process. That's why we have due process. You're for due process for non-citizens as well as citizens? Yeah, just like Justice Scalia, I'm for due process for non-citizens as well as citizens. And again, we don't know the difference. I mean, there are U.S. citizens who've been swept up in these deportation raids. I don't even want to call them deportation. It's not really deportation when you pick people up off the streets and you send them to third-party countries. You send them somewhere where they've never even been before without due process. But yeah, I'm for that because they're U.S. citizens that have been swept up and taken away, and we don't know whether they're citizens or non-citizens or lawful non-citizens or unlawfully present non-citizens unless there's due process. A system without due process is great for a society of infallible people with totally pure motives. But if you believe that we're fallible and that people in power can actually manipulate and exploit their power, then due process is for you. And yet, this is the most basic elemental principles of our jurisprudential system are under attack now. Just like equal protection is under attack. Voting rights are under attack. Civil rights are under attack. You know, I've got constituents, my constituents bring me the most unbelievable stories of things going on. You know, you heard about the Enola Gay exhibit at the Smithsonian. You know, Enola Gay was the name of the airplane that dropped the bomb on Hiroshima and Nagasaki. It was named after the wife of the pilot. Her name was Enola Gay. Well, so, you know, one of the Doge kids, the Midnight Riders, did his little keyword search, and the word gay was triggered in the Enola Gay exhibit. They canceled the exhibit, okay, because it violated, you know, the movement against diversity, equity, and inclusion, and anything LGBTQ related. And I just get reports like this all the time. I've got a constituent. Her job was to assemble pools of cancer patients to make sure, to test new cancer drug. And so she got fired from her job. Why? Well, she had a 3-page job description, and one sentence in the job description said that she should make certain that there is diversity and breadth in the pools of medical patients being assembled for the drug testing to make sure, you know, the drugs would be, you know, would be effective in all cases. She got sacked because she was a DEI hire, because she was told to include, you know, demographic breadth and diversity in the medical pools. So everything is under attack, including all the way to the supremacy clause of the Constitution, which says that the Constitution and the federal laws enacted under it are supreme in the United States. Well, now we have a president and an entire executive branch in unitary executive manner asserting that the president is supreme, not the Constitution, not the Congress, right? The president is supreme. So the services of lawyers are desperately needed everywhere, especially now with the decision striking down nationwide injunctions, because now you've got to go to every federal district court in America in order to make it happen. In fact, even being in a federal district may not be enough if they hold to the idea that the decision applies only to the parties in the case and not to, you know, at least everybody who lives in that federal district. So the demand is exceedingly high, but the supply of lawyers is now artificially depressed by the direct assault on law firms by President Trump and his executive orders, targeting specific law firms by name, like Perkins Coie, where Mark Elias, the great pro-democracy election lawyer, once worked. He doesn't even work there now, but Donald Trump has harbored a grudge against this law firm, and so issued an executive order targeting the law firm, saying that they could not the lawyers could not enter federal buildings and offices, which makes it rather difficult to be a lawyer who goes to federal court if you can't enter the building. They would be prevented from ever having federal employment, from getting federal contracts, and so on. And blatantly unconstitutional, right? And so these kinds of executive orders were leveled against a whole bunch of firms like that, most prominently Sussman Godfrey and Wilmer Hale as well. They went to court and they fought it, and they won on First Amendment grounds, on due process grounds, on the right of their clients to counsel grounds, winning on all of them. But more law firms directly under the gun of President Trump caved in and capitulated, beginning with Paul Weiss, which at least when I was in law school, that was like the most prestigious law firm in the country. They caved in. That's true of Skadden Arps. They caved in. Who else? Kirkland and Ellis, Latham and Watkins, Simpson Thacher, Wilkie Farr. Okay, we cave in. What does that mean? Well, basically, we will comply with whatever you're telling us to do about our hiring of our lawyers, and we will give you pro bono hours from our firm, right? Now, Donald Trump has collected nearly $1 billion worth of pro bono hours from leading law firms across the country. And basically, that means I take it mostly their associates, their summer associates' time, but also their partners' time. That increases the need for pro bono lawyers who are actually on the pro bono side rather the pro malum side. And it also dramatically reduces the supply of lawyers who can be doing pro bono work. Dramatically reduces it because, of course, they're now conflicted out. If you're out there on the anti-choice, anti-environment, anti-labor, anti-vaccine, anti-voting rights side, you cannot send your lawyers now to go and do work on the pro-choice, pro-environment, pro-union, pro-consumer side of any of these cases. You've conflicted yourself out. So all of which is to say, the decisions that you guys make about pro bono are going to be very important because I can tell you, as the lead Democrat on the House Judiciary Committee, and we are involved in litigation all over the country on an amicus basis mostly, we're in desperate need of lawyers who are actually willing to step up and say, I will contribute my time to trying to push back against this onslaught, this authoritarian onslaught against people's rights and their freedoms and the basic principles of the Constitution. So for you, this is primarily like a personal, existential, psychological question, and it's a political question. It's what you want to be doing with your careers and where you want our country and our world to be going. So those are intensely personal meditations you've got to work out with your friends and your family and so on. I will tell you, I've spent pretty much all of my career, I guess I was a summer associate for one half of one summer at a firm, so I can't really advise you that much, but I've spent most of my career in academia or in politics, in government, but I've had the opportunity to take some pro bono cases, and I have found them to be immensely rewarding. For one thing, you don't have anybody above you, like a partner or whatever, telling you how to run the case. You get to do it yourself. You're the partner, you're the associate, you're the paralegal, you're kind of doing the whole thing. Maybe, some of you are at firms that will allow you some of the infrastructural help of the law firm to do it, but you get to be much more in the driver's seat than you would on a normal case that's part of, just the general daily bread of your firm. So you can be, as creative and as visionary as you'd like to be in terms of pressing the client's case and zealously representing them. I was a law professor. I represented a group of students at Blair High School, which is our high school in Silver Spring and Tacoma Park in Maryland. Are there any Marylanders here? Some of you? Oh, wow. Anybody from the 8th District? Well, greetings. Hello to my constituents. Anyway, so these students had a monthly cable TV show called Shades of Gray, where they would conduct debates on different things. And so they were very upset because they had an agreement with the Montgomery County Public School System that the MCPS would run their debates on their Channel 60, which was their, which was our public school channel. And, I can't say that this is like HBO Max or Netflix or something like that. I mean, people would occasionally tune in, but they did have an agreement that on a monthly basis, these debates would be run. And then they had a debate about whether gay people should be allowed to get married. This is back in 2002, okay? And believe it or not, even raising the subject was considered so scandalous at that time that they censored it. They said, we're not going to be running Shades of Gray this month. So the students called me up and they said, can they do that? And I said, well, it kind of depends on why they're not running it. If they're not running it because they need the time for a superintendent address on homework or something like that, then you're kind of out of luck. But if they're not running it after agreeing that they would run your stuff because of the viewpoint of the speakers or the content of the speech, then we might be in business. And they said, well, we don't know. They just said, we're not running it. I said, why don't you send them an email and just say, how come you're not running it this month? So they send them an email back. And like 45 minutes later, they get an email back which says, well, you can tell Professor Raskin that our reason for not running Shades of Gray this month had nothing to do with the content of the speech and everything to do with what the speakers were saying, okay? And I said, all right, we're in business now. And I wanted to go to court, of course, but the students, in their wisdom, actually said, why don't we fight it out in the school system, in the school board? And so we actually designed an education campaign around the rights of students, the rights of the public, the First Amendment. We educated people. They started getting endorsements from teachers and principals and PTAs, and there were all kinds of articles about it and NPR and everything. And by the time we got to the school board, they'd done such a great job that we were actually able to win a reversal of the censorship. It was narrow, but they were able to win a reversal of it and got an agreement to run this episode, which otherwise would have run just once, run it a dozen times. Nobody would have heard about it. It would have disappeared, of course, but suddenly it was like a big deal, and it was just a debate. And for me, it was very valuable because I learned something very interesting, which was that the schools that should be educating young people about the Constitution and their rights are actually trampling their rights and just, brushing them out of the way. And so at that point, I resolved to write a book, which became We the Students, which was about all of the Supreme Court cases that affect kids in public schools and, all of these different struggles about it. So that was one pro bono case that changed my life. There are a number, I won't get into all of them, but there are a number of them that really changed my life in different directions. And so these can be really interesting, significant cases, and they tend to be very case of first impression-like that come to you. It's just that the people involved in them don't have any money. So if you can overlook that, that's cool. I ended up representing like a lot of third political parties who were being totally violated in their rights by virtue of restrictive ballot access laws. In some states, Maryland's one of them actually. If I'm running as a Democrat, and I'm a proud true blue Democrat, I only need one signature to get on the ballot, my own. But if you want to run as an independent, you need 87,000 signatures from all of the different congressional districts with the ward and the precinct and the address numbers of everybody signing and so on. And so I began to, represent some people in challenging these as violations of the Equal Protection and First Amendment. And that actually led to a phone call that I got from a guy, you may not have heard of him, named Ross Perot. Does that ring a bell? Okay. I never know how old anybody is anymore, but anyway, and I met with him, and I assumed since all of these were pro bono, that this would be pro bono, but then he, started asking me what my fees were, and then all of a sudden the light bulb went off in my head. I said, all right, I've got basically two categories of clients, pro bono and pro bono, and you're gonna pay for all of my other clients. Anyway, look, I'll close with this thought. It is a political question, very political question now, what you decide existentially you want to do with your careers. And I'm somebody who's not hung up on, like, do you have a public interest job or government job or private sector or so on. I don't think that's a big deal because of the existence of pro bono and all of the good that you can do from a law firm. And you should just be thinking of it in very practical, pragmatic terms where you can be doing the most good. I mean, I do think you have to be realistic about how much time you're going to be able to spend on this or that. And you can ask those questions and put the law firms on the spot about where they stand right now that we are in the fight of our lives here and this assault is taking place. But I will tell you, you've got to think about this in the broadest political and cosmological terms because this is a fateful moment for American democracy. And I say that not to guilt trip you, but just because I think it's true, and I think we're all part of the same reality here. The Big Bang was, 13 billion years ago, and the Earth came into existence 4 billion years ago, and our species came into existence 300,000 years ago. I think the first Homo sapiens arrived, and our country, we're about to celebrate the 250th birthday of the Declaration of Independence. We only abolished slavery, 160 years ago. We only got the Voting Rights Act in 1965, 60 years ago. Any forward progress we make can very quickly be washed away. For the vast majority of the existence of our species, most people have lived under thugs and dictators and tyrants like Donald Trump or Vladimir Putin or Orban or Mussolini or Pinochet. That has been the fate of humanity. What makes America exceptional is not that we're somehow magically immune to authoritarianism or racism or fascism or anti-Semitism. What makes our country exceptional is that we began with these amazing ideals and values that Jefferson embodied in the Declaration of Independence of the consent of the governed and life, liberty, and the pursuit of happiness and everybody being created equal, right? And that, in the hands of Jefferson, those were self-evident truths. When Lincoln talked about it from the battlefield in 1863, he said it was a proposition. It was a proposition. It wasn't a self-evident truth, but we began with the proposition that all of us are created equal. But the Civil War was testing that proposition, and what we're going through today is testing that proposition again. Will we join most of human history? Will we join most of the rest of the world today where people are living under dictators and authoritarians? Or are we going to stand up for freedom and democracy and the rule of law? That's an existential question for each one of you. What role you want to play in that process of making that decision for us. But I'll close with the words of some of the great democracy patriots who we can look to for inspiration during a tough time. One of them, Frederick Douglass, was born 45 minutes away from here at the Wye River Plantation in Maryland, born into slavery and escaped from slavery to become our great freedom fighter through the Civil War, through Reconstruction. And Douglass said, if there's no struggle, there's no progress. The struggle may be moral, it may be physical, it may be moral and physical, but there must be struggle. Power concedes nothing without a demand. It never has and it never will. So there's a message to you from Maryland in the 19th century. Tom Paine, the great globe-trotting revolutionary Democrat, arrived here in 1774 in Philadelphia and made his way to New York and then around the country. But he fell in love immediately with the land, with the promise of America. He said, if the people here live up to their values and their ideals, it will become an asylum to humanity, he said. Not an insane asylum, all right, but a place of refuge for people seeking freedom from political, religious, and intellectual and economic repression all over the world. And Paine wrote the greatest document of our history, maybe, but certainly the greatest pamphlet called Common Sense, which ignited the American Revolution. By common sense, he meant not just the five senses that we're all born with if we're lucky, but the sixth sense we have, the sense we have in common, he said, if we're willing to reason and speak together without dogma and superstition, what we would call today fake news and propaganda and disinformation, common sense. And that pamphlet spread like wildfire across the country. And George Washington had the troops at Valley Forge reading it by campfire light during the American Revolution. It was so meaningful to people. But 1776 was a tough year. Don't kid yourself. It was a tough year. And I'm reading an interesting book about this right now by H.W. Brands, the Texas historian, called The First Civil War. And it was about how the American Revolution, which we like to think of as unifying everybody and monolithic, in fact, was really like a civil war in how it divided people in the country. It divided families. I mean, Ben Franklin's son, who was the royal governor of New Jersey, stayed with the crown the whole time and ended up in jail. When Franklin was one of the great revolutionaries and patriots of the time. But anyway, Paine wanted to write a pamphlet to give people some hope through a cold, dark winter. So I just want to quote this little passage for you. I'm going to update the language pursuant to instructions from Nancy Pelosi, who told me that Paine was a feminist and he wouldn't mind. And he was a feminist. He was fighting for women's voting rights in the 18th century. But he said, these are the times that try men and women's souls. The summer soldier and the sunshine patriot will shrink at this moment from the service of their cause and their country. But everyone that stands with us now will win the love and the favor and the affection of every man and every woman for all time. Tyranny, like hell, is not easily conquered, but we have this saving consolation. The more difficult the struggle, the more glorious in the end will be our victory. So let's make that victory ours, and I hope you all decide to participate in it. Thank you very much for inviting me to be here. So, thank you, everybody. Thank you. And I take it, I think we got like 10 minutes for people to make their points or questions or whatever's on your mind. I'm not one of those people who says, and make sure there's a question mark at the end of your statement, So whatever's on your mind.
Question or comment, if you want to stand, and we'll have to project because I'm sitting with the microphone, so you start as long as you can.
I hope I haven't depressed everybody. Yes, please. Stand if you would. Yeah, what a great point. I love the contracts analysis there in that, which is, we would, from a constitutional perspective, we'd probably say that these are all coercive contracts based on unconstitutional conditions, right? And And clearly the courts that have ruled, like in the Perkins-Coie case, have said they violate the First Amendment, they violate due process, they violate the right to counsel, which makes it so pathetic that you've got firms like Paul Weiss, some of the greatest firms in American history that are just caving in the face of it. And they must have made the calculation that they could lose, but they'd probably win. But in any event, they would lose business if they were perceived to be on the wrong side of the president. But your point I like very much, which is that as a contract, even before you get to the constitutional questions, this is a contract which could be void as coercive because of the unconscionability of the terms, the massive power imbalance, even with these big wealthy firms, but you've got the entire power of the nation-state apparatus and the president of the United States coming down on them, and the terms being clearly imbalanced and lopsided. I can't remember what the language used in all those contracts cases was. So it would take one or two of those firms to concede they'd made a mistake, to go in and say, look, we see what's going on here. We're in a somewhat different time now. People are fighting back. The universities are fighting back. The colleges are fighting back. And we want to be part of that process. And we'd like to go and be relieved of, pledging hundreds of thousands of hours of our associates' time or our lawyers' time to working for a guy who wants nothing other than to usurp all the powers to himself. So it's a great idea. Somebody should write a summer associate memo about how to go in and get the whole thing dissolved, call the whole thing off. Yes. Yes, ma'am. Well, I appreciate that very much, and thank you for your kind remarks. So I'm the ranking Democrat on the House Judiciary Committee with the ranking Democrat on the Senate Judiciary Committee, Durbin. We just had a shadow hearing. It's a shadow hearing because we don't have the gavels, so we've got to do it, a subterranean hearing. We had a hearing with state attorneys general, and a lot of the state AGs, unfortunately, I think all of them are Democrats, but a lot of them have been standing up strong and bringing suits against the various unconstitutional and unlawful actions. So that's, a great place to go because they're going to be, in the forefront of this. They also have kind of a mini exception from the recent ruling in the CASA case about the nationwide injunctions, because the court said, the majority said, that generally parties can only be in there for themselves and the courts can only rule with respect to those parties. The exception being state AGs because they're acting in parents patriae for everybody in the state. The relief may extend further, including beyond the bounds of the state, making the state attorneys general even more important. But your point is an excellent one that I think the state AGs, the municipal corporation councils, all of them are critical actors here. And because we're under attack everywhere, you can be fighting back everywhere. Public sector, private sector, federal, state, local, county, you name it. And so there is important work to be done in every place. Sir.
Thanks for being here. I hope you enjoyed the 4th of July parade in Tacoma Park.
Were you there?
I was there.
Oh,
yeah. People love you there, clearly. But I have a twofold question. First, when should someone decide to transition from just offering pro bono legal services to running for public office to do even greater good for more people? And can I ask for your support for a congressional candidate, an immigration lawyer, who's going to be running to unseat their eyes in California?
That's you?
That's my boss, not me personally.
Oh, cool, yeah. Well, I don't want to get too partisan here because I've been scrupulously nonpartisan and objective in my comments. But I'm supporting all the Democrats everywhere. I spend a lot of my time on the road campaigning for Democrats. It's funny, I spent 25 years as a constitutional law professor, so I don't consider myself the most partisan person in the world, you know what I mean? Like, and when I was a state senator, I think I had something like 150 bills to my name that were enacted into law, including abolition of the death penalty and marriage equality and stuff like that. But almost all of them were of a bipartisan nature. And Washington has just gotten very extreme in the partisan polarization. And of course, my closest Republican friends in Congress are gone now, like Liz Cheney and Adam Kinzinger, whose office was across the hallway from mine. Mitt Romney's gone, like a lot of these people are gone. But I'm a middle child. I like to bring people together. And so I'm still trying to make friends on the Republican side to the extent I can. But, the question of when one goes from being like a lawyer fighting for the people, which is a beautiful image, to running for office that's of a totally personal, psychological, existential nature. And also you've, of course, got to look at what else is out there. But I admire anybody who's thinking about getting into it. It's a very tough time to be in public life with like the death threats and the violent threats and the meanness. And, I don't know if you saw Donald Trump was tweeting against me or truth socialing against me over the weekend, and he called me a loser in large caps multiple times and said he was going to wipe that smile off my ugly face. And I never thought I was like Tom Cruise or anything, but if I got Donald Trump calling me ugly, I got some serious problems, Anyway, I admire anybody who's willing to go through the kind of the environment that's been created there. And, you've got to look at the particular dynamics of everything, like your family, your kids, and so on. Before this whole nightmare started, when young people would tell me they wanted to go in politics, I'd say, great, but I strongly recommend you have a career, you have some kind of craft or trade, whether it's law or like my grandfather, plumbing or art or something you've been good at. One, because you're going to be far more effective in politics if you've got some ground to stand on and you've got an expertise other people will look to. I remember when I was a state senator, I had a colleague who was a former chief of police in Howard County, Maryland, and everybody would look to him on questions of law enforcement. I had a colleague who actually I now serve with in the U.S. House who's an extreme right-wing Republican named Andy Harris. He's head of the Freedom Caucus now, but he was a surgeon at Johns Hopkins, and so everybody just deferred to him on medical stuff, and I was a constitutional law professor, so people would defer to me, perhaps overly so, in terms of my constitutional analysis and my interpretation. So it really propels your power in a legislative assembly to have some expertise other people can look to. And it also means that you won't be a plaything in the hands of the leadership, which likes to just tell people do this or do that, and you don't want to get into that kind of situation. The other thing, of course, about politics is you can lose, and if you lose, you want to be able to have something to go back to instead of just being a lobbyist, which I guess is the go-to fallback position for a lot of politicians. So, yeah, but let me know about your California friend. So, yeah. Yes. Yeah. I know for a long time it was the Voting Rights Advancement Act. Yeah. It was HR 1, but I'm curious how the threats have expanded, whether the agenda for putting us back on stable footing. Yeah. Well, I appreciate that. I mean, the post-Trump agenda looks a lot like freedom and democracy. And it's funny during this period when people say, well, we're defending democracy. To me, it's a misleading way of describing what's going on, because democracy is not just a static collection of practices and rules. Democracy's always a project. It's always a rough draft. It's always something in motion, and we've got to recapture the momentum of democracy. Tocqueville said in Democracy in America, that he observed democracy and voting rights are either shrinking and shriveling away under the attacks of power, or they're growing and expanding. And we got to get back on the growth track. I mean, you guys are, I don't know how many of you go to school here at Georgetown or whatever, but I mean, you're seated in a city right now, which is the only national capital on planet Earth where the people are not represented in their own parliament. So we got to start talking about statehood, and I'm not talking about Greenland and Canada and Panama. I'm talking about Washington, D.C. and Puerto Rico, millions of American citizens who are disenfranchised. And, you know, Article 4 statehood admissions have always been a critical engine for the growth and expansion of democracy. And I was proud in the 116th and 117th Congresses that I was the floor leader, along with my friend Eleanor Holmes Norton, who was a distinguished professor at this law school, for statehood for D.C. And when I got up, I said I want to thank the 713,000 tax-paying, draftable U.S. citizens living in the District of Columbia who have a verifiable, bona fide political grievance against the national government, and yet didn't come down here and beat the daylights out of our police officers and storm the Capitol and try to overthrow the government. They've done it the right way in petitioning for statehood, and we should recognize that the way that the 37 prior statehood applications have been admitted by those of us, like Maryland, who were in the original 13, not to show off or anything, but yeah, that is very much part of the dynamics of democratic expansion in the country. And you know, Puerto Rico has seen what it means not to have any voting representation in Congress or even a vote for president. D.C., of course, has it under the 23rd Amendment. But you know, that's just the beginning. We've got huge constitutional changes that need to take place. We still don't have a constitutional amendment guaranteeing the right of every American citizen to vote. We didn't start out that way because it was up to the legislatures, and the vast majority of the people couldn't vote. It was generally white male property owners over the age of 21. And it's only been through this trajectory of democratic expansion in the post-Bill of Rights amendments that we've begun to approach a more perfect union in something like, you know, the vision of our last great Republican president, Abraham Lincoln, of government of the people, by the people, and for the people, right? But that is the story of America. I mean, the 13th Amendment abolishes slavery. The 14th Amendment gives us equal protection. The 15th Amendment bans race discrimination in voting. The 17th Amendment shifts the mode of election of the U.S. senators from the legislatures to the people. The 19th Amendment doubles the franchise in America with women's suffrage. The 23rd Amendment gives D.C. the right to participate in presidential elections. The 24th Amendment bans poll taxes. The 26th Amendment lowers the voting age to 18. The vast majority of those amendments are about deepening and expanding the meaning of democracy, and we got to get back on the growth track. We've got millions of people who still can't vote in America, and then millions of people who theoretically have the right to vote, but whose votes have been stripped away, including by the Supreme Court in the Shelby County versus Holder case, which just disabled the Voting Rights Act by, you know, knocking out the pre-clearance requirement by dismantling the coverage formula, which they said, you know, was out of date. So we need a full-blown democracy agenda. We need a full-blown agenda to restore the proper powers of Congress, many of which have been stolen by the president, but also a lot have been given away by Congress, and we got to take them back. I mean, a lot of members of Congress don't want to declare war because, you know, they'd rather the president usurp the power, and then if it goes well, they say, I was with you all the way. Or if it goes poorly, oh, you know, he didn't even come to us, we would have voted against that. You know, that's not a responsible way for members of Congress to think about the war power, you know, or any of our lawmaking powers. So it's time, you know, like there's something really to what Jefferson said, that every generation needs to have a democracy revolution, and we need another transformation here, politically, socially, economically. High burden of hope rests on your generation. And I'm going to do whatever I can to help you guys out. Yeah. Thank you, Ben.